like to thank Judge Gaden. That was very informative. I'm in General District Court a lot, and I definitely took a lot from that presentation. Our next speaker was elected to the Henrico County Circuit Court in May 2012 by the Virginia General Assembly. He received his undergraduate degree at Washington and Lee and received his JD from University of Richmond, so right here. He has previously served as judge for the 14th Judicial District Juvenile and Domestic Relations Court. And I won't tell any more stories, but please welcome Judge Wallerstein.
Good morning. Thank you for the opportunity to speak for a few minutes about civility, decorum, the things that everyone aspires to do with his or her practice. I thought that the communication between the audience and Judge Gaden was perfect, and so please feel free to have that same type of rapport with me so that any questions you may have or comments, we can have more of a discussion as opposed to a lecture. Joel, thank you for the opportunity to speak. With the opportunity to talk about ethics and respect, honesty, those types of things, I think that it's a lot like cooking spaghetti. You know, you throw it on the wall, some of it sticks, some of it doesn't, but hopefully the more you throw, the more you have an opportunity to stick. I also would like to thank my judicial intern, Brooke Cargman, who's a third-year University of Richmond practice or student. She's my judicial intern for this term, and she did yeoman's work with the preparation of the outline, so thank you, Brooke. And also thank you for being here, so if there are any mistakes, you can go ahead and address those to Brooke as well. Since David Letterman retired and he had his top 10 list, he has passed those on to me, so I'm going to give you a top 10 list of things to do or not do as far as your practice is concerned. And I've been accused of speaking in metaphorical speech, and so I would go ahead and confess that I think that sayings that other people have made that make sense to me, I adopt and use those as points of reference or contact for the future. So here we go. Just because you have one doesn't mean you have to be one. Think about it. Okay? If you don't take anything away from my talk, take that one away from it and keep it in your head. Just because you have a rear end doesn't mean you have to be one. And in your practice of law, there'll be opportunities to make decisions about how you want your reputation and your practice to go. And I will tell you that the most effective lawyers, just like Judge Gaden said when she left, the most effective lawyers are the ones that are civil, that are honest, that have the respect of the court, and do the right thing. The ones that decide that they want to be one as opposed to just have one, those are the attorneys that we judges in the back halls and in the mandatory conferences and so forth, that we talk. And judges are people too, contrary to popular belief. We talk. And if you have an unfortunate experience with one judge, don't be so myopic to think that it will remain with that judge and not go down the hall to his or her colleagues. You can be civil in all aspects of your practice and be very effective. If you treat people the way that you would like to be treated, your practice will soar. If you treat opposing counsel the way you would like to be treated, your practice will soar. Contrary to what you may think, or if you're taught in our adversary system that it's a win at all costs, it's not. Your reputation will be what people remember of you as you move from one case to the next to the next. And if you have been civil, respectful, prepared, do a good job, that's all part of your reputation. Joe DiMaggio said, "There's always some kid who may be seeing me for the first or last time. I owe him my best." The corollary is this. If you are an attorney who has not appeared before a judge, or if you are a seasoned attorney, much like Judge Gaden just talked about, the old-timey lawyer, the old-school lawyer that comes in and wants to remove a case when he or she can't, it's important to do your best. Now, certainly everyone can't be on his or her game every day. That's just not possible. But doing your best is important. It's important for you. It's important for your client. It's important for the case. And so the way that I would suggest to you to try to do your best is not to wait to the last minute to prepare your case, because invariably there's a time crunch in your practice and you can't do the quality job that you want to do when you don't have the time in which to do it. The practice of law is demanding. You have lots of competing interests. You have senior partners who want things to be done. You have clients who want things to be done a certain way. You have student loan creditors who want things to be done a certain way. Rent payments, mortgage payments, in other words, they're financial obligations that you want to make sure that you can cover as you go. And so all these at times can be in somewhat conflict with one another. But what I will tell you is, if you adopt a win at all cost philosophy, then you will not become the attorney that you want to be. And everyone has gone through the 12 years of high school. It took me a little bit longer than that. The 4 years of undergrad took me a little bit longer than that, and the 3 years of law school took me a little bit longer than that. But eventually you get out and you get the piece of paper and you think, I can do anything. I've got my bar certificate. I've got the Supreme Court of Virginia. I might have the Eastern District of Virginia federal. So I'm just as smart as I can be. Well, contrary to, I think it was the Scarecrow in The Wizard of Oz, who didn't have a brain, and all of a sudden they got a piece of paper and the Scarecrow was smart. The piece of paper does not make you as smart as you might think that you are. The definition of insanity is doing the same thing over and over again and expecting a different result. Albert Einstein said that. So, if you're practicing law a certain way, trying a case a certain way, and it's not working for you, the fact that it hasn't worked for you one time is not necessarily fatal. But if you try it again and again, and you're still coming in second, maybe the idea is that what you're trying is not going to produce the results that you're looking for. So it's a good idea to step back and say, I don't want to be insane. Maybe there's a different way to skin this legal cat. And if it is, think about it. Learn from other people's mistakes. You can't live long enough to make them all yourself. Eleanor Roosevelt said that. So don't be so myopic to think that if somebody else is making a mistake, that you would never make that same mistake. Keep your eyes open, keep your ears open, see what's going on, talk to people, listen to people, and do not make the same mistakes that the other lawyers make. So, for example, getting back to Judge Gaden, a lawyer comes in and says, Judge, I want to remove this case. And Judge Gaden, in her very just genteel style, says, I'm sorry, counsel, we're unable to do that for you, not to embarrass that attorney. Remember that you can't remove a case from General District Court. Don't try to go ahead and do that when it hasn't worked for somebody else and there's a reason. Success is 90% preparation, 10% perspiration. It's like painting. When you're painting a room, it's going to take you 9 times as long to prepare the wall for painting before you start painting. The painting itself is the 10%. The preparation of the wall with the spackling and the sanding and getting everything done is what's going to take your time to do that so that the finished product looks good. It's only as good as the preparation that you have. Louis Pasteur said, "Chance favors the prepared mind." So if you are prepared, if you do that preparation, if you put 9 times the amount of time into the preparation and 10% into the presentation, you will do well. And maybe it takes more than 9 times at the beginning if you haven't tried a particular type of case. There's nothing wrong with spending countless hours, and even if it's on your own time and you can't bill it to a client, or if you have it on a contingency fee and you're thinking, well, even if I win this case, I'm going to get about $1.50 an hour. It's important to prepare your case so that when you go into court, you are prepared, you have that confidence, and you're ready to try the case. It takes about 20 attaboys to overcome 1 O. There's a 4-letter word that I don't know whether it's being recorded or not, and I'm subject to reappointment in about 5 years, so I think I'll just leave that term off. But it starts with S and it ends with T. And what that means is if you make a mistake, then it's going to need to be about 20 good deeds, 20 really good things to kind of level it out. So, is it better to try to avoid that 1 O, you know what? Yes, it is. How do you do that? Preparation, perspiration, talking to other lawyers, learning from other people's mistakes, making sure to the extent that you can when you go into court that your position is well versed in the law, there's a basis for it, you have a good faith argument for it, and you're not trying to play fast and loose with your co-counsel, and especially with the court. Remember, they call it the practice of law. Everyone practices till they get it right. And I know very few people who have gone beyond the practice and say that they absolutely have this right. Because as we all know, the law is shades of gray. There's nothing definitely black and white. And it's the lawyers that paint the shades of gray to us judges to try to convince us that their position is superior to the other. Experience is not what happens to you, it's what you do with what happens to you. Aldous Huxley said that. It's how you handle the adversity that you will eventually come across in your practice, and whether you will remember that as a cornerstone or an important part of your practice to not do that again. The fact that it happened, please don't be so naive to say, well, that could never happen to me again. Because if it happened once, it doesn't mean that it will never happen again. Wise men don't need advice. Fools don't take it. Benjamin Franklin said that. If you think that you're smarter than everyone else that has ever donned shoe leather and become a practicing attorney, congratulations. But you may want to re-examine that thought. I believe that it was Icarus who flew a little bit too close to the sun, notwithstanding the advice from his father, and it didn't go very well for Icarus. The corollary is if you are flying too close to the sun judicially, it may not go extremely well for you as well. Listen to the corollary of Icarus's father. Listen to people who are in your firm, people who you respect. You can have a conversation with people in Henrico, the city of Richmond, the Richmond metropolitan area. We are very blessed with a bar and with a judiciary that are willing to reach out, to be contacted, and if there's some questions. And so if you want this, here's my phone number. You can write it down. 501-5252. And if you have a question about a case that's not in my court and is not likely to be pending in my court, so you can't call me about a Henrico General District Court case because it may end up coming up. Without giving you advisory opinions, I can talk to you about certain things, and I would be happy to do that. If it's late at night, I'll give you one of my colleagues' home phone numbers, and you can call him and get that same quality of advice. Light travels faster than sound. That's why some people appear bright until you hear them speak. Better to remain silent and be thought a fool than to speak out and remove all doubt. Abraham Lincoln. And probably as important, you have 2 ears and 1 mouth. You should listen twice as much as you speak. And that was sage advice from my elementary school teacher. So all of those sayings are kind of wrapped into this point. If you are a relatively new attorney, listen. You can learn a whole lot about things by just listening. You can also learn a whole lot about things by observing. Everyone says things that they may may wish that they could take back, but to the extent that you can reduce that unfortunate circumstance, then that will help you. So listen twice as much as you talk. It's okay to be thought that maybe you don't understand what's going on. But when you open your mouth and you don't know what you're talking about, that's worse. Keep that in mind. The weight of the evidence is not measured by the pound. And what I tell people is this. If you send into my court a 75 to 100 page brief on a relatively narrow issue, and the other side sends in a 5-page brief on that same issue, I'm not persuaded that the 70 pages that are submitted by one lawyer is more persuasive than the other. Write as succinctly as you can. Write as efficiently as you can. Everyone is a word merchant. And if you can say what you want to say and convey your point in a sentence with a $1 word instead of a $5 word, nothing wrong with that. So They say that brevity is the soul of wit. I think also in the rules of court, brevity is enjoined as the characteristic of a good pleading. We judges typically have a fairly rigorous docket, and some of the lawyers that invoke the lawyer's creed of never doing to today what they can put off till tomorrow, we will get a 75-page brief followed by a 5-page response on the day before the hearing. And from my standpoint, how motivated am I to make sure that I have everything understood and fully understood and read everything when it comes in by email or fax to my chambers at 4 o'clock on the day immediately preceding the hearing at 9 o'clock. Many times the other side would say, Judge, we just got this at 4 o'clock the same time you did, and we're not prepared to address the issue. And it becomes a question of fairness or equity. And there are more times than not that I would say I believe that's a very well reasoned position. And so we're going to kick this can down the road to give the other lawyer an opportunity to fully and fairly address these 75 pages of what the issue is. Reputation is what other people know about you. Honor is what you know about yourself. Louis McMaster Bujold said that. Folks, all you have is your time and your reputation. That's all you get when you practice the law. You certainly have your bar card and everything, but your time and your reputation are the wares that you have when you're practicing. You want to guard your time as efficiently as you can, because you don't want to be single dimensional in your life. You can't be always a steward of the law and not have any life outside of the practice of law. Nor should you have the corollary and just wait and kind of come in and do things by the hip because you're enjoying outside of the law more than you are your duties of practicing law. But the honor that you have is kind of like your conscience, Pinocchio and Jiminy Cricket. Jiminy Cricket was the conscience for Pinocchio because he was not a real boy. Pinocchio needed Jiminy Cricket because he wasn't a real boy. We don't need to have Jiminy Cricket. We all have that voice inside of our head. That's our conscience. And our conscience is our honor. And those are the things that you should keep inviolate. It's like a shiny penny. Keep it shined. If it goes dull, do what you need to do to shine it again. Because your honor is part of your reputation. It will follow you, and if it is good, it will help you in every aspect of your practice. Everybody ought to do at least 2 things they hate each day just to have the practice. William James said that. So here's the thing. Everybody's got stuff on his or her desk that they just hate to do. That's the nature of the practice. Something you need to respond to, but you don't have to do it right away. It's human nature to say, you know what, I'll just kick this can down the road, I'll do it tomorrow. But if you do it when it comes in and you get it off of your plate, I will tell you that your feeling about yourself and about your practice will be elevated beyond having it sit there and waiting for it for tomorrow. Because when you leave at the end of the day, that document is sitting on the corner of your desk, and that's probably the last thing you're looking at before you're grabbing for your keys. And it's the first thing you see the next morning when you come in. So do what you hate at the beginning, get it done, and the rest of your day will be much more enjoyable than that little thought in the back of your head, I still need to do this. The lawyer's creed is applicable to this as well. Try to avoid it. Don't do today what you can put off till tomorrow. That's the lawyer's creed. Do it today instead of putting it off till tomorrow, because invariably something that you're going to hate is going to come in tomorrow as well. And then you've got twice as much stuff that you hate to do. Return your phone calls. Reply to the emails. Do not send out spirited responses to jerky emails or phone calls. I recommend that you let them sit for about 24 hours and just simmer. Eleanor Roosevelt said anger is only one letter short of danger. So in my old school practice, somebody would send me a Dear Jerk letter, and I'd have my dictaphone, and I was like, Dear Jerkhead, thank you for your nasty letter of such and such date. Should you have a brain in your head, you would have realized it would have been this, and the other. I hope you eat you-know-what and die. By the way, thank you and best wishes, Ricky Wallerstein. And so I'd fire that letter off, and I was feeling really good about myself, And this was, like I said, this is old school, so I'm not typing my own stuff. I'm handing the little micro cassette to my assistant, and my assistant types the letter. And for some reason or other, I'm not getting the thing back. I want to just sign that letter and just send it off. I want to make sure it goes out in the mail as quickly as possible, because I don't want to wait for this jerkwad I want him to get my response. But she was very clever. And every time that I asked for it, she would say, I know I have it somewhere, let me find it and I'll get it to you. And it would take probably about 24 hours before she would find it and get it to me. And I'd had my butt off my shoulders by that point in time, and I had reconsidered sending the letter. Because when you send the letter, when you say things by voicemail, when you say things by phone, when you email things, it's like toothpaste, it's out of the tube and you can't get it back. So if you are inclined to do that, my advice to you is, it's somewhat cathartic to write the Dear Jerkhead letter, but it's a significant mistake to send it until you've given it some secondary, mature consideration. And once it's out there, you can't get it back. And if it's an email or a voicemail and somebody's a jerk, then it just gets passed along in the law firm, and everybody knows about it. So it's not just confined to your arch enemy that you might have on this particular case. Return your phone calls. Reply to the emails. Do it in a manner that you would like to receive that message to you. It's the golden rule, do unto others the way that you would like for them to do unto you. Not the lawyer's golden rule of doing unto others before they do unto you. Yes, sir. That's my next. That's fine. No, that's exactly right. You're replying to phone calls, whether it's to clients or whomever, will do two things. It will, my number one point, it will help you avoid a bar complaint. A bar complaint comes to you in an envelope that says Virginia State Bar, and at the bottom it's marked personal and confidential. It's not Chief Justice Lemons contacting you to ask if you'll give him some legal advice on a case. It's not. It's not good news. And if it's a big firm, here comes this personal and confidential letter from the Virginia State Bar, and who knows whether the protocol in your firm is to open up the letter and, go ahead and date stamp it and so forth, and that person has read it. And if it's sitting on that person's desk, then somebody else has read it. And a complaint from the bar is like a kick in the gut, regardless of whether you've done anything wrong or not. It's at least an accusation from someone that you've not done the right thing. So nobody likes to get it. Can you avoid it? Don't know. It depends on the nature of your practice and the way that you handle things. But there are some skills, as this gentleman had said, that will lessen the likelihood of a bar complaint, and that's client contact. Even if you don't want to tell your client that you came in second, it's better to let the client know that they came in second instead of saying, we haven't heard anything, kicking it down the road. When you're disingenuous with your clients, if you're disingenuous with your senior partner, because if the senior partner is working on the case with you and they get a phone call from the client saying, I'm trying to get in touch with Joel. I've called him 10 times over the past 2 weeks and I haven't heard back from him. No email, no voicemail, no nothing. How's that going to go when the time comes for your evaluation? And maybe that client is like, if this is the type of client representation I'm paying $400 an hour for, maybe I need to be thinking to take my bag of marbles somewhere else. Because as we look around and we know that the way it is, if a town's not big enough for one lawyer, just bring in another. There's always another lawyer that's willing to take your case. The third thing it will do is increase your business. It'll increase your business within the clients that you have. And clients are just like lawyers or judges. Clients talk. And if you've done a good job for one client, then that client's going to talk to somebody else in a cocktail party situation and say, I know everybody hates lawyers until they need one, but why don't you, I had a good experience with so-and-so, and they got back to me, and I didn't like what they had to say, but they were very candid with me with regard to the things that they said. They kept me posted on the way that the case was going. One of these bears repeating again, and that's where I started. Just because you have one doesn't mean you have to be one. And if you keep that in mind as you go through your practice, you will do fine. Some of the other things that are in the outline that Brooke helped put together, some comments that I'd like to make, and then if you have some questions, we can certainly open up the discussion. Please know your case better than the judge. It's important when you come in and you're trying a case to be able to be better prepared from the judge. You may be receiving some very pointed questions from the judge, and while it is possibly okay to say, Judge, I don't know the answer to it, it's much better to say, Judge, that was a very good question. All we judges like to hear that, right? And the answer is this. And if you would like, I have the case of Smith versus Jones that support this position. And you have 2 copies, one for the court and one for your opposing counsel, because it's kind of the sharp practice of law. Judge, this is for you. I don't have the case for the other side. They can get it. And that's not good, because I'll probably say, well, Mr. So-and-so, why don't I let you look at my copy that the counsel passed up, and when you've had a chance to read it, let me know if you're in a position to want to argue that today. Learn the judge's styles, the likes and the dislikes. Some of my hot buttons and it's especially on criminal cases, people are coming in with their shirt tails out, with their pants below their waist, and I think that shows disrespect for the court. So appearances make a difference to me, so I'll ask my deputies to take the people outside and say, would you kindly tuck your shirt tail in, pull your pants up to your waist, and have the belt. It's just, it means something to me. I'm less concerned about it if it's a witness, because these witnesses are being subpoenaed and they are coming in. Most of them don't want to be here. I view there's a difference between the litigants and the witnesses, so I might cut them a little bit of slack. But some of the things is inescapable. When I was in the juvenile court, I had a defendant come in with a wife beater on, and it says he was charged with assault and battery of a family member. And the front of it says, when I want your opinion, I will beat it out of you. For the possession of marijuana, they'll come in with the normal T-shirt, the National Organization for the Reform of Marijuana Laws, with the whole marijuana plant just screen printed on the top of on their T-shirt. Certainly a message, but the question is that the message that you want to send? As a young lawyer, I represented a gentleman who owed some child support down in the Richmond Circuit Court, and Judge Wilkinson, who has passed away, but he was a longtime circuit court judge. My client came in looking like Mr. T. I mean, he had more gold jewelry and diamond rings and everything on, and he was the payor. And he gets on the stand and he says, I can't pay my child support. Well, Judge Wilkinson's like, you could sell that rope gold chain that you have around your neck and the diamond earrings that you have in your ear and so forth in order to help these starving kids pay the child support. So appearances matter. Talk to your client about how he or she are going to dress coming to court. Now, I ask people not to come dressed like they're going to a prom. The slit and the high heel shoes certainly shows a lot of decorum to the court, but we don't really need to do that. If it's something that your client can do, I refer to dressing like Rebecca of Sunnybrook Farm. If you're the downtrodden person, come in dressed with clean clothes, but you don't have to put on a $600 suit. Dress nicely, but in keeping with the theme of your case. As a side note, and I don't know whether war stories are permitted in this, but I had a 3-day murder trial this week, and my criminal defendant, they have an absolute right to have street clothes on during the trial, so that there wouldn't be any possibility that the orange jumpsuit would unfairly impress the jury. Well, his family brought him some clothes, but he's a skinny guy, and they brought these clothes that just were voluminous, and so he refused to wear the clothes. And again, not that I'm all that altruistic, but I usually keep a clean shirt at the court, and so I asked the deputies, I said, ask him if he wants to wear my shirt. So he was very grateful to wear my shirt with my monogram on my sleeve and everything. and so he comes into court for the jury trial, and he's dressed. He's looking good, So it's important to know your client. It's important to talk to your client about dress code, those types of things. No need to dress like the prom, but also you don't want to come in having been digging ditches unless they have just left their job, and that's the only way they can get in court on time. Learn the likes and the dislikes of the judges. Some of them are more mercurial than others. I think it's important to know whoever your judge is, what he or she likes and dislikes. Certainly, if someone is arguing a point and I interject and say, I want to understand what you're saying, are you saying this? Or if I ask the question before the other side gets to ask the question, the lawyer goes, Judge, that's exactly the point that I was going to make. Well, certainly makes me feel like I'm one of the smartest people in the room. But do it without being so laudatory to make it think that you're just blowing smoke up my skirt. It's a nice way to have my sensibilities and ego somewhat codified or reinforced, but try not to be so disingenuous that it makes me seem like you're just kind of damning with faint praise. Yes? We don't have any like that. That's right. Well, first of all, you say thank you, and that's my next point, is whether you win or you lose, when you're walking out and you say thank you, Your Honor. And you don't have to say out loud enough that the judge to hear is that was absolutely the worst decision that anybody has ever made in the case. And you can wait till you get out of earshot of the judge and then go and talk about an appeal. If a judge is more of an activist judge and they're asking the questions, I've heard people say, Judge, with all due respect, if you're going to try the case for me, please don't lose it. You need to be careful about, trying to know the personality of the judge. Some of the judges are going to think that's kind of funny. Some of the judges are going to think it's contemptuous. So know your judge. But if the case is just going down the tubes because it's just one of these days and you cannot catch a break, just do your best. If there are objections, make your objections in a very respectful way. Make sure that you are making the record, because should there be an appeal, that the record is clear. And do your best. But don't give up. But don't be, just because you have one doesn't mean you have to be one. Yes, sir.
If the judge disagrees with an objection and is interested in moving the case along and not stopping to hear the full length of the objection, what's the most tactful way that you've seen somebody try to make a record of the other objection points?
Well, two ways. Number one, if it's not a really long objection, say, Judge, with all due respect, if I could go ahead and put on the record my objection, and if it ends up being that you would need to proffer what the, if the objection was overruled, what your client was going to say, you'll need to do that. Also, you can say, Judge, during a break, if that would work, I'd like to preserve my objection, and then during the time of the break, go ahead and put on the record the full portion of what the proffer would be. And you can do that. Does that help you with your question? Okay. Introduce yourself to the judge until the judge says, Mr. McClellan, I know who you are. Thank you. Thank you for doing that. Because we're up there, we've got the case, we're ready to go, and there's somebody that walks in whose name is not listed on the docket, and you should know who that person is, but you don't. You may have seen him or her, or that you've never even seen that person before, and that person stands up and starts arguing the case. The best way to say it is say, may it please the court, I am Ricky Wallerstein, and I'm representing the plaintiff in this case. The old school lawyers still do that. And if it's a record, it says who you are. And it shows respect for the court. And then, of course, the court's going to be going, of course, Mr. Wallerstein, it's so nice to see you again. I knew who you were because the judge is making you look good as it relates to your client. If you've never been before the judge, give your business card to the bailiff. The bailiff then gives it to me, so I can say at the beginning of the case, this is the case of Smith versus Jones. We have counsel for the plaintiff, nice to see you, Mr. Johnson, and counsel for the defendant, nice to see you, Ms. Smith. And then the clients are thinking, hey, I got some person that really knows this judge that's helping me, right? I mean, that's all part of it as well. This is client relations. And if the judge goes, and I'm sorry, you are, and nice to meet you, you're always welcome, welcome to the court, the client is like, holy smokes, I got somebody that the judge doesn't know, and the judge is like, well, Mr. Jones, good to see you, and how's your family, and da-da-da-da, and so the parties have some impression that they are already at a disadvantage. Do your recon work. If you've never come before a judge, me, I'll just use it as an example, show up in my court and sit in the back and see what I like, see what my style is, talk to other people, and if it's a jury trial, get with our court administrator. If it's a civil jury trial, ask the court administrator, when is the next time Judge Wallerstein has a civil jury trial, and show up and sit in the back and take notes. If it's a criminal case, same type of thing. There's nothing wrong with having some legwork to have that level of comfort when you're getting ready to do that. Also, if it's your first jury and you don't have somebody that's helping you, you may want to get with the deputies and say, can I talk to you about how the strikes work? Because a lot of the jurisdictions have it differently. The federal court strikes are on a clipboard, and in Virginia, in my court, it's in this big book, and the book gets passed back and forth. And then if it's a civil case, each side gets 3 strikes. If it's a criminal case, each side gets 4 strikes. But in my murder trial that I had this week, because it was going to take several days, I decided to seat 2 alternates. So instead of each side getting 4 strikes, each side got 6, and that's how we got down to 14. So we had, instead of 20, and each side gets 4 strikes to pare it down to 12, I sat 26, and each side got 6, paring it down to 14. So those are the things, if you know the logistics of it, then that helps you have a level of confidence when you're ready to try it, that you're going to be focusing on what you need to be focusing on, and that's the trial of the case as opposed to the logistics of it. Let's say you've had your hat handed to you by the judge. Just say thank you. Just say thank you, and don't say anything under your breath. And please coach your client to not say, that judge is an asshole, when they're leaving, because it's probably going to cost that person 10 days that they did not necessarily expect. Be early, be on time. I tell kids when I sat in the juvenile court, if you can be 5 minutes late, you can be 5 minutes early. And it's important to me. I usually hit the bench 10 minutes before the docket starts, and then people are like, oh my gosh, the judge is already there. I don't hold it against you if you're not there and sitting in court 10 minutes early. But a lot of times what can happen, if it's a criminal case and the prosecutor's there, or if it's a civil case and both lawyers are there, we can start before the appointed hour, and you can get in and get out more quickly than if you got there at 30 seconds before the appointed hour. Do not be habitually late. I know the lawyers that are habitually late. There are lawyers that have practices much more active, that show up on time, than the ones whose practices are not as busy and they are habitually late. And so if a judge, in a nice way say, oh, well, Mr. Smith, it's nice to see you again. Should we call your 9 o'clock cases at 9:30 in the future? Might be a nice way for the judge to say, why don't you try to get here at 9 o'clock? And as I used to tell people when I was in practice and I was chasing receivables, it's okay for my bill to be on the bottom of the stack at one time of the month, but it's not okay to be at the bottom of the stack the second month, the third month, the fourth month. So if you're going to be late, try not to be late to the same court over and over and over again. Share the pain with some of my colleagues. Try not to overbook your schedule. It's a conflict between having an active practice, having your billable hours, making the money that you need, and being in more than one place at the same time. I had a coach at W&L, and he had these metaphors, and he says, you can't be in two places at once without a station wagon. It didn't make a lot of sense, but the idea is you cannot be at two places at once at the same time. So if you're supposed to be in Chesterfield at 9 and you're supposed to be in Henrico at 9, how are you going to do that? One of the jurisdictions is going to have to wait for you. But if the time comes to set the case and you already have 3 matters in Chesterfield and the Henrico judge says, can we set it on that date? You have 2 options. You could say, Judge, I have 3 matters in Chesterfield that morning at 9, so I would imagine I could be here by about 11:30. Would that work for you? And the judge says, well, no, because our docket starts at 9:30 and that's not going to work. How about a different day? And it's okay to get a different day. But if you put that Henrico case on a different day, and then you also have 2 other Chesterfield days, please don't go to Chesterfield for those 2 cases the second time. You booked Henrico first, and that deserves first billing. Criminal cases. Criminal cases, you see the worst people acting their best, and the converse is on civil cases, you see the best people acting their worst. You don't have to fall for it. You don't have to be part of that. If your client says, I want you to rip off this person's head and spit down their neck and win this case at all costs, I will submit to you is that's not the type of client that you want or you need, even if they're paying your bills. Because what they are doing is they are controlling the case, and as the lawyer, you have an inherent right to control the case. In a criminal case, there are 4 things that are sacred to a criminal defendant. The right to have a jury or non-jury, the right to plead guilty or not guilty, the right to testify or not testify, and the right to appeal or not appeal. Everything else is within the province of the criminal defense attorney. And so you should not, cannot let the tail wag the dog. You are the lawyer. You got the piece of paper. You're the ones that know what is going on. And even though your client may have the purse strings and says, I'm not going to pay you unless you do this, think about whether that's the type of client that you want or that you need. Because they're going to put you in a situation where your ethics are going to be called into question, and it's generally not good for the lawyer. I also tell people Try not to be more than maybe the second lawyer on a case. Every lawyer's been fired, and then everybody has picked up somebody else's case. But if 2 people have been fired or 3 people have been fired, you're much like the guy behind the elephant in the parade. And you want to try to avoid doing that, no matter how lucrative it might seem. There may be somebody that's around that you think is so stupid that they can't pour water out of a boot with the directions on the heel. That everything they say is stupid. Everything they say is wrong. I will tell you that my adage is that even a broken watch is right twice a day. So no one is always wrong. If you think that they are always wrong, then you're the one that's always wrong. Keep that in mind. Everybody's going to need a favor at some point in time. Rules of court say you've got 21 days to respond or 28 days to respond, those types of things, and you're waiting for your interrogatory answers from your clients, and they're just not forthcoming within the 21 days, and you don't have the ability to put them into appropriate form and then get your client to come in and sign that under oath. Please pick up the phone and call your opposing counsel and say, hey, I need an extension. Don't wait until after the 21 days runs and have that person write you a dear jerkhead letter, you've missed the 21 days. And especially if they're old school, if there's somebody from my white hair generation, they don't do too much of this emailing and texting and that type of thing. Pick up the phone, show the decorum to the person that you're trying to contact that you think that person deserves. If in your practice it's all emails and voicemails between people of a like generation and that works for you, that's fine. It's only going to work as well as until somebody says it didn't work. I was out of the office, I had my out of office reply, and I was unable to address this. So if there are things that are ministerial in your practice, can I have another week or 10 days or 2 weeks to get you your answers? Typically the lawyer is going to say absolutely. Typically that lawyer does not need to contact his or her client and say, can we give them 10 days or 2 weeks to respond? If you do that and the client says, absolutely not, I want you to file a motion to compel, I want you to go to court, I want you to ask for sanctions, and we're just going to rip off this person's head and spit down their neck, get control of your client. Because that client, you are controlling the case, they are paying you good money for your experience, for your time, and please let them know that when there comes to matters of great importance, you're going to consult with them, but this is something that you have and that you believe is going to come back to benefit your client in the long run. You have to distinguish that between someone calling up and saying, hey, I know I missed the statute of limitations. Can you agree to waive the statute of limitations or not plead that as an affirmative defense? Nice question. That person might be a very good friend of yours, but those are things that I think are inviolate. I don't think that those are things that you can properly say, I can extend that professional courtesy to you. The way that I would always say it is, I would love to do this, but my client just won't let me do that. You guys are much too young, but there was a used car salesman here in Richmond called Madman Dapper Dan, and his slogan was, I'd give the cars away, but my wife won't let me. The corollary is true. I would love to help you on this issue of statute of limitations, but my client won't let me. And that's after you've told the client, do not agree to this. Okay? The sun does not shine on the same dog's head every day. And so someone's going to call you up and ask for a favor. If you're going to be a jerk to them and say, absolutely not, I'm going to court on the motion to compel, if this person is not habitually late, and if there is a good faith reason why the person is late, as a judge, I'm going to give some mature consideration to extending the time to respond and take the motion for sanctions under advisement. There will come a point in time where you will need the same favor from that person or a member of that person's firm, and just like we judges talk, lawyers talk. So thank you again for the opportunity, and you have my phone number. And again, if you need an after-hours phone number, let me know, and I'll find one of my colleagues to send that to you. Good luck, folks.